Today, I am joined by Nayan Padre and he is the president of Ecomback. Ecomback has the best ADA website lawsuit reports in the game, and we're going to go all over Nayan's latest report in this episode. But we're also going to talk about accessibility and the law generally. So we're going to get into a lot of topics, but Nayan has been very deep in this space. You've been looking into laws, and the one that comes to mind is AB 1757, and talking about them. You have talked directly with the W3C, the World Wide Web Consortium, who are the creators of the Web Content Accessibility Guidelines. So Nayan has a lot of knowledge, a lot of information, and we're going to get into a lot today. So Nayan, thank you for joining.
Thank you, Chris. Appreciate it. And this has been a couple of years in the making, I think, this call.
Yeah, yeah. And so something that everyone doesn't know is that we've been talking for a long, long time, off and on. And when I saw your report, I was like, this is what I've been waiting for. This data, and I know you put it together meticulously. Like this is something that requires a lot of time and a lot of energy, but it's so well done. Can you tell everyone like what goes into a report like this?
So we have a data team that scrapes every single lawsuit that we can find using various databases on a daily basis, and we read those lawsuits and we compile extensive Google Sheets and Excel sheets and other ways of tracking all of the data that's in here, essentially from who the plaintiffs are, who their attorneys are, what platforms that they're the websites that are being sued are on, what is in those allegations, and it's a very rigorous process that requires an intense amount of data scraping and data analysis that goes into it, and it's all manual.
And I know this firsthand because I've attempted it. It's extremely difficult to do, and it's always incomplete because you can never get everything, especially with when you look at the California state courts, it's difficult. So you always have to just try the best you can, even though it seems like it'd be straightforward. This is a very time intensive process.
Absolutely. And whatever numbers we have, I bet you they're at least 20% higher because the state courts and certain counties are extremely difficult in how they don't classify the type of lawsuits that are being filed. So oftentimes, we have some tricks of the trade that we use to find plaintiffs or to find patterns of lawsuits, or we get tips from people, but it's very difficult. On the federal level, it's a little easier, but on the state and local level, it becomes a lot harder and costly. None of this is free. I mean, we publish it for free, but we spend an enormous amount of resources to put these reports that we publish together.
That's a good side point is like, now this should be publicly available information, but you actually have to pay to find out what should be public. So it's like and access isn't easy. It's like sometimes it's like it's not reported on. So
Yeah.
this report is extremely valuable. So let's go ahead. I'm going to share my screen and we're going to get into some of the data to start with. So let me select it. And how long did you take to put this together?
Oh, so this is part of our daily work, and usually the mid-year report can take about a month to put together. We publish quarterly or monthly reports, but more recently we've been doing the larger features like this. And this is the compiling the data is done on a daily basis, and then on a monthly review, and then a quarterly review, and then putting all the news elements together. So it's about a month's worth of work for the team.
Well, it's really well done. So we've got it on the screen now. We've got the 2025 mid-year ADA website lawsuit report. Again, this is from Ecomback. we've got this nice executive summary. So can you take us just through the general, what's happening with the lawsuits?
So I was actually very surprised that last year we saw a little bit of a dip, or it was stagnant, but this year it's 37% up between January and the end of June, same period last year. So lawsuits last year had taken a little bit of a decline, and I think that's partly due to some of the law firms that were filing, hundreds of cases backing off a little bit, or moving to state court, or moving to demand letters. And this year there have been some new entrants in this space, and they're filing more aggressively than what we've seen in the past. And this is not a good sign for small businesses, and it's certainly not a good sign for the state of the industry, I think.
And so one thing that happens in this industry when we look at different companies and different agencies is they take a fear-based approach, which I've always disliked. What I like is the data, which is what you have. And this is very much like, hey, like, like there's no need to have these headlines where you're trying to scare people into purchasing your products and services. This is very straightforward. I mean, as you just said, 37%. We haven't seen a jump like that in I don't even know what, 5+ years.
Yeah, it's well, what's happened is the concentration used to be in New York, California, Florida, Pennsylvania, but this year you have other states like Illinois, Missouri, so forth, that are showing a large influx of litigation, basically. And what's interesting is some of the lawyers that are representing, that are based in the in states like New York, are also admitted in other states, and they're filing those lawsuits in other states. So essentially, it's become more widespread than concentrated as it used to be.
So let's go ahead and we'll scroll down now. And this just shows what you're talking about. Statewide 88 website lawsuits filed. Here we can see the data. We can see New York and Florida dominating, California not too far behind. Um, why is it that California has fallen back in this? California used to be number two.
Well, in California, there's more demand letters, which we can't track because they're private,
So
right?
that's a really important point that most people are unaware of is that this is even more pervasive. Like you might hear like, okay, I don't like several thousands of complaints filed in court. It's way beyond that, right?
Well, from some defense attorneys that I've spoken to over the years, they say that for every lawsuit that they deal with, there's probably 7 to 10 demand letters. So whatever numbers you're seeing, add a zero to them.
All right, so we've got 2014 total. And by the way, this is the mid-year report, right?
Correct.
Yeah,
Our
so
2024 report, also the full year, you can go back in and look at that one, but this is our mid-year report.
all right, so let's go ahead and scroll down, and then we've got this section that's just it's very timely because we were just talking about demand letters. So it's like it might not be that the complaint is filed against you. It might be that you get a letter in the mail that tells you, you get um, an indirect threat that we're going to sue you, but you can settle. Is that how it usually plays out?
Yeah, they call it pre-litigation letter. I call, it's, other people call it shadow litigation, because essentially what they do is and I've seen a lot of these letters by some attorneys that are of repute and some attorneys that are of ill repute, I think. But they will attach to the letter an unfiled draft of the lawsuit. So it's like, here's the lawsuit. I haven't filed it yet. Here's my letter informing you of my intent to file this lawsuit. What do you want to do? And on paper, it sounds great. Like, hey, okay, yeah, we got an opportunity to, resolve this out of court. But therein lies the problem. It becomes shadow litigation.
And what a lot of clients ask me is, well, is there a grace period? Like, do we get it? Is there time? Do we have time to fix our website? Like, basically, like, is this letter like I can go ahead and make the fixes, right? I'm always telling them like, no, it's once you get the letter, that's what we want to avoid at all costs. We don't want the letter because once the letter happens, the loss has incurred. Is that what you think?
Absolutely. There is no grace in most cases. I mean, in some cases, yes, there are folks that are genuine and who definitely are trying to do the right thing and try to inform, businesses, or whether it's a college or whether it's an agency. But for the most part, it's kind of like, um, hey, we can either sue you or we can talk business. You know,
Yeah, yeah,
it,
and
it
and
is
and
what it is that simple.
it really is. And this is, as you said, like of course, we're talking on a whole, but 99.9% of this litigation is serial litigation where these plaintiffs' lawyers are suing people on repeat. This is not typically a situation where someone genuinely wanted to access something and they were unable to, and nobody provided any support. This is we found a website and we're going to sue this website.
Exactly. And you know, um, what's happening is, if you can, if you scroll and read the report, you'll see that 31 plaintiffs drove 50% or more of the lawsuits in this year. So it is quite a few lawsuits for a very small amount of people, and a lot of those lawsuits don't proclaim to be quote unquote tester status. They are saying that they experienced quote unquote discrimination by visiting a website for bona fide purpose, which probably is contestable if that purpose was bona fide or not. But that's kind of what's happening, where you have a small concentration of law firms, and you have an even smaller concentration of plaintiffs that essentially are doing this day in and day out in the name of advancing accessibility.
Yeah, so we've scrolled down to the section 50% of ADA website lawsuits were filed by 31 plaintiffs, and then you've got the plaintiff name and the law firm name and the law firm names. So we can see here it's the same, it's not always the same. We see new entrants because just other plaintiffs lawyers are recognizing like, hey, I can, this is a money printing industry. But we do see litigation driven by the same plaintiffs law firms over and over again. So I'll go ahead and scroll down. Let's see what else we can come across.
But I want to point out something here, 1 second, Chris, if you don't mind, is that the ADA in and of itself does not provide for compensation, but the ADA does not have any punitive damages. But California and New York have, under California's UNRU statute, there are statutory damages, and under New York's Human Rights Commission, or I forgot the exact full form of the commission in New York, someone who makes an allegation, and if that allegation is proven to be valid, post a whole process, would be entitled to $500. But in California, it's, I believe, $4,500. So if you're filing 100 cases in 6 months, that's 400 grand.
Yeah, this is extremely lucrative. I mean, there are definitely, what would you say? Like some of these plaintiffs' law firms are making tens of
No,
millions
I'm just,
annually.
I'm talking about just the plaintiff itself.
Oh,
You know,
just the plaintiff himself. Yeah,
yeah,
I was thinking of the law firms. And
yeah,
here
but
we've got. Oh, go ahead.
yeah, but the plaintiff law firms, some of them are, the range, the settlement range can be anything from 2,500 to 25,000. Usually it's between 10 and 20,000. Some are less, some are more, depending on who your lawyer is. What they think you can pay essentially is a lot of it. So it is, my fundamental question is, was the ADA designed, or are disability rights designed for this type of litigation.
Absolutely not. Of course not. This is, this is not what the ADA was designed for. Not the spirit of the ADA is to find technical instances of accessibility or inaccessibility, and create litigation over those, right? So, I mean, but this is the landscape that now so many, it's not just the large companies, as you mentioned earlier, it's the small businesses too, and they are significantly affected and that sometimes going out of business because of this. And one other note here, we're going to talk more about just digital accessibility and litigation later, but one note, Nayan, you've actually created a documentary on this. So you've conducted some investigative research into this, and I want to talk more about that later. But I just want to let everyone know who's watching this video that Nayan knows the inside of this, like the actual like the behind the scenes of what's going on with these lawsuits.
Absolutely. So I started making this film about 3.5 years ago with my partners. And we uncovered the premise of the documentary was to figure out two things can be true at the same time. The world should be more accessible. There's, I don't think anyone's arguing against that. But is suing every small business in America the way to do it? And if that's the case, let's figure out who's doing the suing and who are the plaintiffs and who are the law firms and what are their practices, because um, there are certainly ethical questions that one has on how all of this is driven and what is the profit motive behind it, basically, because there is a profit motive behind a lot of this, and there's nothing wrong with having a profit motive. That's what business is for. But what the larger issue here it is that how are these plaintiffs being recruited? Because the funny thing is some of the plaintiff law firms, their own websites are not accessible, and some of them use the very widgets that they sue others over. So it's like, if your own website's not accessible, well, how did you find this plaintiff? And we found out how they find some of these plaintiffs, or how the plaintiffs wind up at these law firms. And that's what's going to be exposed in the law in the documentary, is the underbelly of the disability rights and accessibility litigation industry.
And I've got to preview this documentary, and I'll just say that when it comes out, you definitely want to watch it. It's really, really good. Let's go ahead and let's get through this. I just right now what's coming to my mind is we're screen sharing this whole time, and I want to exit the screen share, but before we do, I want to cover more of this report because there's so much good data in here. Here you've got the top law firms. We're going to go through that. 57% of ADA website lawsuits filed by 5 law firms. Yeah, I mean, some of them, I mean, really, truly an industry here, right? We're talking tens of millions of dollars on this. And you've got some industry trends,
Hundreds of millions of dollars. So
hundreds of millions of dollars.
since 2016 to 2022, if I'm not mistaken, or 2023, there were about 25,000 lawsuits. I'm not including 2024 and 25. So say 30,000 lawsuits. The average cost to a business of one of those lawsuits, after having studied what businesses have paid doing an anonymized study of reporting by defense firms, defense law firms, and by businesses themselves, was about $20,000 is what it was costing them between the settlement, their legal fees, and the remediation costs. And usually those remediation costs were minimal because they were adding widgets, which leads to the second lawsuit. So if you look at that, you're talking about $600 to $700 million. And I'm not even talking about the demand letters in that number. So if I add the demand letters, it's probably north of $1 billion since 2016.
So this is the huge industry that really, even to date, Nyan, one thing that I don't it's just it's not quite mainstream to me. Like it doesn't seem like more, it doesn't seem like this has really taken hold as this is something that is actually happening, can and will happen to you, but we just don't see. I just, what do you think? I don't, the way I interpret how people react, I don't think they take it, they don't treat it with the gravity that it actually presents.
Um, it is because it's something that most people starting a business are not contemplating anything like this, right? It's you have to do a lot of research to figure this out, and also it's also a little confusion in how the ADA is presented because there's Title One, Title Two, Title Three. In Title One, it's about employers and their minimum guidelines on minimum requirements of how many folks you have working for you. So a lot of businesses don't fit that. So they think, okay, it doesn't apply to me. Title Two is the government. And Title Three refers to public accommodations, but it doesn't mention the internet. So most people don't really know their legal obligations if they even exist because it's still contesting in court whether or not the ADA applies to the internet or what portion of the internet does it apply to, meaning that the nexus with having a retail business or brick and mortar business and the website being an extension of that versus just solely an online business. So there's a lot of gray area out there. And of course, one can argue, well, you can research this when you start a business, but that's easier said than done when you're trying to, just navigate life and navigate running a small business and dealing with the challenges that exist on a day-to-day basis. And that's part of what the film is. The film is called Blindsided, and that's the film talks about that as to what is the role of technology and our technology providers. What is their role in all of this? So I think a lot of businesses mean well, they just get caught blindsided in this, and that's the name of the film, Blindsided.
100%. And it's definitely something that if you don't know about it, then then most people don't, they're completely unaware of even the concept that they can make their website quote unquote ADA compliant. Um, what I was getting at was like, take Shopify, right? Shopify store owners have been targeted relentlessly, but like Shopify's response hasn't, to me, has not matched what the problem for their customers, right? Like the severity of the problem for their customers. If I'm Shopify, I'm doing a lot more to help my customers, and I haven't seen as much of a reaction from Shopify. And the last I looked, which was might have been a year ago, their guidelines stated that they did address accessibility, but their guideline was that to have a theme accepted into the theme store, it needs to pass Google Lighthouse, which, as we both know, that's a start, but that's definitely not going to be anything that um, will prevent a lawsuit.
No, absolutely not. And there's arguments on both sides. Shopify and the platforms are providing you a code base or CMS platform where you drag and drop, and there's all these hundreds of millions of different apps that are out there on the Shopify App Store or for WordPress or for any of the other larger providers or people who custom code websites, which are larger entities that do that. So the blame can't solely be on any platform and it can't solely be on the business. There have to be tools in place for businesses to know that this is a thing that they need to be aware of, and there have to be tools for them to be able to check um, uh, what barriers people may face. However, and this is something you and I have talked about for a couple of years now, the metric by which they can check, which is the WCAG guidelines, are not something that you can check using automated tools. You have to do manual testing because these automated tools can only check 30, 40, 50% at best of what the guidelines specify. And right now, the challenge is we're living in the age of AI while we have guidelines that were developed in the age of dial-up, so to say. So we're trying to retrofit websites using older guidelines. And I'm not saying that they're not valid. What I'm saying is that there's so many more advancements in technology that are out there now where the problem of accessibility on websites can be solved in large part, not 100%, but in many ways through newer technology. And I'm just afraid that we're not using those advancements, but we're kind of strapping on WCAG to newer or older websites when there are alternatives out there, and their alternatives are going to continue to get better and better, specifically with AI-enabled browsers and chat, which is creeping into the search space and into the browsing space in a very big way, if that
And
makes
I
any
want
sense.
to, once we get through the report, I do want to add something to what you just said, but um, let's continue on with the industry trends here. Can you just tell us, and I've got this pulled up, like from like what are you seeing trending? Because you operate a company in this space. What is it from your vantage point? What do you see happening the most?
Right now, what I see happening a lot of is websites that are using overlays, getting hammered with demand letters or lawsuits. And we're gonna, and like we've talked about, we track what widgets are being cited in these lawsuits a lot. And what I also see is repeat lawsuits, which is something that we're going to work on identifying, because sometimes it's a little hard to identify those. But um, we see a lot of clients coming to us and telling us that they were sued several years ago and now they've been sued again. And um, I think businesses need to be aware of the fact that this is not something that you should ignore from several points of view. One is obviously, if you can make your website accessible, you should endeavor to do so. It's outside of a legal obligation, which depending on the state you're in may vary, but it's something as a moral imperative. But um, it is something that might catch up to you, especially if you operate in one of the higher risk industries, which is clothing and apparel and restaurants. And we have also broken that down as to which platforms are getting sued, what the percentage of those are, and then what types of industries are getting hit.
So you have here restaurant, food, drinks, and beverages at 30.49% of the lawsuits, then lifestyle, fashion, clothing right by it at 28.8, and then beauty, skin at next at 8.89, medical and health at 7.15, and then it continues on from there. But you know, a, so many industries have been a part of this, and um, what industry is targeted is somewhat flippant. I think it's more normalizing at this point, but I've seen, I've heard anecdotes where the plaintiff's lawyer will just decide one day it's one thing, and then the next month it could be a completely other another. And it's not like there's like a specific pattern. It's just whatever they've decided to, whatever types of websites that they've decided to target. Um,
Well,
but
that's the question. Who's driving it? Is it the plaintiff, or is it the plaintiff attorney, or is it their scraping team that's finding websites that have issues, and then it just so happens that the plaintiff visited that website on a given day or not?
And on this next section, you have common reasons for ADA website lawsuits, missing or incorrect image alt text. Alt text is the number one most commonly claimed issue, and it's actually one of the easier ones to take care of, and but it's also one of the easiest ones to have like accidentally not have it, or just not be aware of a certain image that isn't marked as decorative or doesn't have the meaning relayed. But here you've got all of these issues laid out, and then you include pop-ups and overlays without accessible controls. Okay, so this isn't overlay widgets. You're talking about the cookie banners, the chat pop-ups, the third-party integrations that can be problematic in terms of technical accessibility issues. And then we have the widget usage fails to prevent ADA lawsuits. Can you speak to this?
Yeah, so um, a lot of businesses install overlays because that's what shows up first in the Google search results, right? You have um, these heavily funded providers who I believe mean well. I don't think that they don't mean well. Maybe they should modify how they market themselves, which the FTC has chimed in on recently. But they install these overlays and they think, well, I've provided, you know, what I could as they're proud to kind of like have this widget on their website because they feel it's like a badge of um, good, good intention. But what they don't realize is that overlays, for rightly or wrongly, are not solving certain issues that folks may encounter while using assistive technology. And it becomes, in a way, low-hanging fruit for lawsuits because they don't need to really test whether your website is accessible or not. You got the overlay, and that itself is quote unquote a red flag, as a plaintiff attorney says in my film. It's like you have that overlay, it's like you're literally waving a red flag.
Yeah, yeah, I was about to ask you about that because you've talked to plaintiffs' lawyers and at least one has told you, right? Like, look, if they've got an overlay widget installed, like that's just a signal that they're about to be next.
Oh yeah, absolutely. And you know, um, it's, I would say, how do you address accessibility if you can't do it at scale? Um, you can't, because there's no way to manually go in and fix, billions of websites. But overlays and widgets have some purpose. I don't, we're in the business of helping businesses. We don't use overlays, we don't create overlays, we don't have overlays, but I'm not going to bash them because I think they serve a purpose. And if they can help make the world more accessible, then we should give that a shot. But they can't at the moment, or at least they can't as they're advertised. But at the moment, what's happening is just the presence of the overlay itself has opened up doors for litigation now.
Well, I'll definitely bash them. Like they can, just because something is available at scale doesn't mean it works at scale. So like, yeah, like we could install overlay widgets on millions of websites by tomorrow, but that doesn't make them effective. And the problem to me is that not that they exist and not that they have to be inherently bad, but that everybody knows the game that's being played is that use this widget, and then there's some kind of ambiguous messaging that it will somehow either prevent a lawsuit or be a temporary stopgap or some kind of solution or in some form or fashion. And website owners are buying under this impression because they're not buying, like, some may be thinking like, okay, I'm genuinely improving my website. But the reality is that these widgets aren't being treated as such when it comes to lawsuits. So that's typically why people are installing widgets based on my own experience talking to literally hundreds and thousands of people. Is like people think that, okay, now I'm protected against this lawsuit. And that is one of the primary problems I have with them is that the messaging doesn't match the reality. And we
Right.
have seen this. We have seen this with multiple class action lawsuits, as well as the FTC. I don't even know what the correct term would be, sanction, let's call it, but Yeah, I mean that would be my primary problem with them.
What what I'm gonna give it a little bit more leeway, and in the sense that if there was an overlay that through the use of AI could advance accessibility, it should not be, the baby should not be thrown out with the bathwater, basically. And that's kind of my point, is that as technology evolves, we should be open-minded in allowing for um, things that may not have worked in the past to be able to work in the future. I say this against my own best interest. We basically remediate websites at the code level, so you won't need an overlay. We don't do it any other way. However, I'm not here to, bash anyone else. We're just presenting the facts here in our report, and we just want folks to understand the data in its most granular form available, and then come to their own conclusions as to what's right for them, if they're a business using this, or if they're a regulator or a lawmaker, or any kind of person that's involved in technology, as to what it is that they should do to ensure that there's wider accessibility in the online space. And unfortunately, litigation seems to be what is driving some of this.
And I want to, so one other thing I want to talk about is AI and the ability for AI to just supersede, right, some of this. But let's go ahead and end up with I just want to cover one last snippet of data from your report. We have the ADA website lawsuits by website platform. Here we can see custom coded websites at nearly 35%, Shopify, as I was talking about earlier, 32.42%, WordPress at 21%, and then we have Magento and Squarespace. So I'm actually surprised that Wix isn't in here.
Wix is actually one of the most accessible. We see 1 to 2% of lawsuits on Wix. It's also got less adoption than Shopify does in terms of the type of websites that use Wix are probably not as uh, e-commerce driven in a sense. They're more informative usually. So that's, and Wix also has a more advanced accessibility tool set than others do.
Well, that's a good point on the type of the websites that are being used by the different platforms is because Shopify is the most targeted, not because it's Shopify, but because it's e-commerce, right? Like it's like if you have an e-commerce store, then you are much more likely to be targeted. Whereas if you just have like this is my website, like a full of information, that's not going to be something as targeted.
Correct. And the problem with, it's not inherently Shopify themselves, while they can certainly improve the themes that they come up with, but it's the assortment of apps that are on the Shopify App Store that are not accessible, and that introduce problems that are impossible for anyone to remediate other than the provider, because we don't have access to their code. The business doesn't have access to their code. They have access to their code. And Shopify ought to do a better job of um, allowing apps onto the App Store that meet certain um, benchmarks of accessibility, or not allowing them. Because what tends to happen, Chris, is that one app might conflict with another app and might create issues that are unbeknownst to the business owner. Or an app, I'll give you a perfect example. There's a very good app for privacy, and every 3 months they come up with some kind of new code base change, and they overwrite the accessibility work that we have helped them do. And then we find the problem and we write to them, and it's usually a small fix, and it'll take a couple of days. But in the meantime, the million websites that are using that app have suddenly now introduced accessibility barriers unbeknownst to them.
Well, and then they also there's that, and there's also the fact that they have accessibility apps that are for ADA compliance and so on. And like just knowing that these aren't stopping the lawsuits, this is I mean my when I take issue with Shopify's like meager stance, it's not because that I think Shopify is to blame for accessibility. Like, right, that's on the website owner. Obviously, Shopify could provide more in terms of like just like let's say because the themes are involved here. It's not just straight Shopify. It's also these third-party themes. I think yes, there could be more instruction, more of an awareness on Shopify, but also just like if you let these apps persist on your platform on the store, then people like a lot of people still think that they're going to stop lawsuits when they don't.
No,
So
it's what I've actually seen, and it's kind of crazy, is that um, businesses that have tried to do um, try to app their way out of this problem are the ones that get hurt, or the ones that get um, these lawsuits the most, basically. And it's kind of paradoxical because they're trying to do the right thing, right? And in doing the right thing, they've actually now, and that's in my film. There's a gentleman who himself has MS, and he's like, I tried to do the right thing, and he's got MS, and he's being sued for intentional discrimination, which is the state of affairs.
yeah, you've got this business owner who himself has a disability, and
Yeah,
he's now being sued because he's told that his website is inaccessible.
because he
Uh,
was using a tool that provided accessibility.
yeah, and he tried, and Um, yeah, I mean, there's multiple different dynamics going on at the same time, and I
Yeah,
think that's also what a lot of people they don't like. It's not that just it's not you're not able to parse through this right away, and so it's like you just find out about this through a lawsuit, and then you continue forward, and then you like you said, the first research results you'll come across are the companies that are selling widgets, and they'll send their messaging, and then you've got their messaging so it's there's just different dynamics to keep in mind. And one that you mentioned that I think is a really good it's really good to thought experiment is with AI. So what we will see, and I think what I don't think this is far away, is just that AI will have the ability to act as a tool, like right as to help someone with access to where for certain let's just say for a website, it won't need to be technically conformant with the web content accessibility guidelines to still be accessible because AI will bridge that gap. AI will be able to circumvent any technical issues that would have been in place and help someone with access. So I think that's correct me if I'm wrong. Is that part of your point earlier about hey, like I'm open to this new technology and not just so focused on the web content accessibility guidelines?
absolutely. I don't think they're guidelines, they're not standards, and they should not be shoehorned into becoming standards. That's not what they were designed for. They're not a legal document. They're not easy to understand by any means whatsoever. They're not easy to implement by any means whatsoever, especially by people who are used to the drag and drop world of website creation. Um, so they have their place. They have never been widely adopted. And there's probably a reason why they have never been widely adopted by the tech industry. Uh, so one have to look at, if these guidelines are so great, why haven't they been used to the extent that they could have been for the last decade? So that's one aspect of it. The other aspect, and that's probably controversial, and some people probably might not like that, me saying that, but that's the fact. When WebAIM comes up with their report each year and they talk about 95% or whatever that number is of websites having issues on their homepage, that's tells you that the industry hasn't really succeeded in making the web accessible at scale. So what can make the web accessible at scale? It's wearables, it's AI, it's AI agents, it's all of the new um, world of tech that we're living in and will continue to live in. So I think uh, pegging accessibility to decade-old guidelines, um, which is what the DOJ has recently done now, is, in my view, a little dangerous because it might prevent those resources from being deployed into where they can have the most maximum impact. Does that make sense? You know,
It does.
investing in creating web spaces using AI and using the next generation of the web that we live in now, we may be legally forced to use guidelines as a quasi standard. And I'm not comfortable with that.
Well, I think so. First, it's very easy to have a technical accessibility issue when you are when you're up against when you're comparing against these technical standards that are the web content accessibility guidelines. As you said, I agree with you. These should not be a legal standard because if you make the web content accessibility guidelines a legal standard, or if you incorporate or adopt it into the law, what happens is then you're in a place where you are forced to face the fact that if you have one instance of nonconformance, it could mean you are technically in violation of the law, technically, potentially discriminating against people with disabilities under the law, which is not the case. And this is why I think it's so important for legislators to be aware of just how difficult it is to fully conform with the web content accessibility guidelines. It is extremely easy to have a technical accessibility issue, but having a technical accessibility issue does not mean your digital asset is wholly inaccessible. It just means you have a technical accessibility issue. And with, I think, with the European Accessibility Act, we have this being shown because I think the drafters were very, they took a very smart approach here, and they brought forward the principles of the Web Content Accessibility Guidelines, which are the core principles: perceivable, operable, understandable, and robust. But they didn't actually incorporate or adopt the Web Content Accessibility Guidelines. Now, still, I would recommend conformance just because it just makes it easier rather than trying to, you know, only meet the principles. But I think they did a really good, that was really smart of them because they recognized that, hey, if we incorporate these technical standards, it's like one instance means you're in violation of the law, which we all know is not the case.
Well, what the charged allegation here is, under all of these lawsuits, is every single one of them, almost, I think, I haven't found one that doesn't, let's put it that way, references the WCAG. What they say is that by you not conforming to the WCAG, you are, quote unquote, by policy and practice, uh, intentionally discriminating against people with disabilities. And I think those things are very charged allegations in today's world, where you are telling a business, a lot of the times a mom and pop business, many times people who have disabilities run those businesses. And you're telling them that they are, quote unquote, by policy and practice, discriminating against people with disabilities because they failed some conformance checklist of the WCAG, which I can guarantee you, if you or someone audited the website of the WCAG or the W3C, they may find some instance on some page of nonconformance. Does that mean that the W3C is, quote unquote, intentionally discriminating? I don't think so. They could find that on anyone's website. I mean, it was hilarious when the DOJ came up with, when they were going to announce this, uh, they had, prior to the 20 2024 Title II regulation, they had come up with this kind of guideline document, which was kind of like a nothing burger. But that document itself, that page on the DOJ's website, was not accessible.
Well,
So is the DOJ quote unquote intentionally discriminating against people with disabilities because they had some errors? And I'm the one who pointed it out to them at a conference when they announced it. And I just feel that marrying the CAG, or using, I should say, using the WCAG as a barometer or as some kind of metric for discrimination is very dangerous grounds and should be looked into, because I don't think that it's valid and that's what its purpose is, and it should not be abused like that.
Well, you also spoke out against AB 1757, and I like this is not me speaking for you, but me telling you what I my position is. I think you single-handedly stopped that from becoming state law in California, which I think has done a tremendous service to, the digital world, and very few people know that, but that was an extremely dangerous that was extremely dangerous legislation.
Absolutely. And I don't think you and I have talked about this at length, and um, I've never publicly talked about my um uh role in trying to stop AB 1757. Essentially, while we were making the film, I came across this uh bill that was being advanced in California, and then I looked at it, I'm like, this has got to be a joke. This is ridiculous. And we reached out to the lawmaker's office and try to understand what was going on. But that bill was moving like a snowball, downhill and getting a lot of traction. And I saw the danger in that bill and started a website called Stop AB 1757, which got the attention of folks. And then, through word of mouth, we started enlisting help to reach out to lawmakers and to the folks that were advancing this bill. And I think it was like 3 or 4 times they tried to advance it. And I worked with them closely to try to redraft it, but it was putting, lipstick on a pig, and it wasn't going to fly.
Well, and one other thing I wanted to note is that when we look at YouTube videos, technically YouTube videos are non-conformant with WCAG. So it's like, and by the way, I have YouTube videos embedded on accessible. And then I just say that to say that it's so easy to have an accessibility issue, so that when under the law, we strictly apply the web content accessibility guidelines, then we just create more problems. And what we want to do is make the digital world more accessible. What we don't want to do is enrich plaintiffs' lawyers to where we've got this separate industry where it's like every time you have one accessibility issue, then then that gives rise to litigation, right? We don't
Well,
need that.
I would challenge, and I remember you had asked me to jump on a call with a client you had once, and I think they told us that they were in the process of removing pages from, it was a entity in Colorado, if I'm not mistaken, and they were in the process of removing large chunks of their website. And that was not the first call I was on like that, where what happening is that businesses and agencies that are now covered under Title II are saying, this is beyond our scope of understanding. This is beyond our means of remediation. So the board has voted to simply have a landing page and shut off everything else, and whoever needs services can come into the office. Do you remember that? Like, we had talked to this guy and he said, that's exactly what he said, was like, we're going to shut down large portions of our website that we can't make accessible, and it's too difficult for us to do so. And I've spoken to businesses also who have asked for help, and we try to go to their website and it doesn't exist because it's got a landing page, and they say, well, we've decided that there's too much risk involved, and we'd rather just have a simple landing page and not um, uh, be at risk of spending tens of thousands of dollars that we don't have on things that are, in their view, predatory.
Well, and I talked to one client who was a small business owner, and she just took her website down, and it was she no longer had any on, like, you couldn't purchase anything online, and and she said it's just not worth it. Like, I don't want to, like, I don't want to constantly be have this idea that I might be sued. And I actually recommend it as a viable option. I think it's one of the options that website owners have, and at times I recommend it because it's less expensive, and it's a lot of times it's just easier and simpler because if you're, when you get sued, for most people it's like this is completely upending their schedule. Mental energy is lost, time and money is lost, and so I can understand why people don't want to deal with it.
No, absolutely. And I think that it's almost a form of, I don't want to use the word censorship, but it's something in that space where you would rather essentially go dark than have to deal with being accused of discrimination in a class action lawsuit, um in, federal court in New York or in any other state, because it's a shock to the system. A lot of small businesses, are selling online to, barely pay their bills basically. And when they have things like this happen, it kind of shakes your faith in your place in the world and what you're doing, and it very demoralizing. And I don't think that anyone who's advancing disability rights or accessibility intends for that to be the consequence of enforcing guidelines.
Well, I think that's what can be the case, right? We can advance accessibility and not promote litigation, because we don't the two don't need to be together. We can improve accessibility, and so many of the clients I've talked to are completely open to accessibility, but we definitely don't need to sue everyone just because they have an accessibility issue or multiple accessibility issues on their website or other digital asset. I can tell you, as a small business owner, it's like there are things that you're like you find out about and you're like, I completely didn't know I had to do X. And then now it's like one more thing, and you're trying to grow a business at the same time. It's extremely difficult to stay on top of everything.
Well, absolutely. And the thing is that it's a problem created by technology, which is website barriers, and it's a problem that should be solved by technology. And making the world more accessible by suing every small business in America is probably not the best use of resources. And it's certainly not what states like California or others should be putting on the table as an option. Part of that AB 1757 was that plaintiff lawyers would not only be able to sue the business, but to also sue others involved in the making of the website, which was something that was advanced by some lobbying groups, some business lobbying groups, because they felt, oh yeah, why don't you sue the platforms, or why don't you sue these providers? But what they don't understand is that this is not something websites are not built in isolation. They're a partnership and a cooperation between the business or the agency or whoever and a group of providers. So creating litigation by way of regulation or by way of laws that don't see the unintended consequences is a bad idea, basically, because all you're going to do is further litigation and further this discontent, or this uh, feeling that the from a small business point of view, that the stakes are against us. And I don't think anyone who's advancing disability rights that I've spoken to, and I've spoken to a lot of people, in especially making my film, and have worked with a lot of folks who have disabilities, and I continue to work with them on a day-to-day basis, they don't want that either. And I don't want to speak for anyone else, but at least the people I know or I have spoken to have never expressed any kind of delight or joy in the fact that businesses need to get sued.
And when we look at what's happening just more broadly, right, we have these small businesses which can generate value, can promote commerce, and help stimulate the economy, grow the economy, versus we have now they are being hampered by by litigation. And so the valuable money that they need to grow business, grow commerce is being diverted to plaintiffs' law firms who are providing little to no value in this case because all they're doing is suing people over and over again over website accessibility. So that's also bad for the economy, just to be engaged in that practice.
Well, Title II regulations that the DOJ has put out, which mandate conformance with WCAG, is going to cost the government $35 billion, apparently, from their own estimates, something in that range. $35 billion to retrofit 96,000 or 100,000 websites by state, local, federal agencies. You're talking about small fire departments, small libraries, things like that. It's an enormous amount of money. Using standards of 2016, 2017, or whenever they were updated is kind of irrelevant. But not using forward technology, not using chat, not using wearables, not using AI, not using any of that, but tying accessibility to those. So that's a big concern I have. And it's something I'm speaking up about. And that doesn't mean that we should not advance accessibility. It just means we should understand where we are in the world today in technology and where it can go and use those resources to go forward, not backwards. That's one main thing that I really think we should think about it. And on your point of litigation, sometimes litigation is necessary and sometimes it's a good thing. It's not always a bad thing. What the problem here it is that the settlement amounts have no basis in any kind of earned fees. I believe you used to be an attorney or
I'm
many
still an
attorneys.
attorney. Nothing changed.
I'm sorry?
I'm still an attorney.
Okay, so you're an attorney. So I don't think you could just say, Nayan, I think today you owe me $10,000. No? Okay, well, how about 8? No? Well, how about 7.5? You usually bill by the time that you have spent on a case, right? And there should be transparency in a settlement. Who gets what? And what are the earned fees? How much time was spent? Not how much time could be spent if I took you to court. So I want to be paid for that time, the time I'm not billing by not dragging you through endless litigation. So you got to pay me a fraction of that right now. That's my problem. That there is no accounting basis on which these numbers are thrown out. And a lot of it, and a lot of business have told me, and I can attest to this, where they say, show us your tax returns. What the hell does that have to do with anything?
They want to see how much they can extract.
I've talked to businesses that have put their settlements on auto pay on their personal credit cards, $250 a month, $500 a month. It's like a bad debt collector in a sense, right? So what does that have to do with advancing accessibility? I don't think anyone's able to explain that to me. How is that a good thing? Nobody's ever been able to explain that to me because they can't, because it makes no sense. And I think it's time that small businesses or any business, it's kind of irrelevant the size of the business, but particularly small businesses. I spoke to someone the other day who could barely speak English. They were Asian and had been sued and were completely flummoxed by what to do, basically. A lot of the people that are being sued don't have the wherewithal or the understanding of what is happening. All they know is someone wants $10,000 to not take them to court, and is it a good idea to just pay them to make it go away? And that should not be how accessibility or disability rights are championed in this country or anywhere else for that matter.
What I mean, all this is leading to is like, where is the common sense? Like, how is this practical in any way? And you're right, like, I'm not against litigation. Sometimes litigation is necessary, but here, this is not necessary, and this is not what we're seeing. We're not seeing that people are their civil rights are being violated. That's not what the case is here, is that we just have several plaintiffs lawyers who are engaged in suing people over and over again because they can identify some technical accessibility issues.
I mean, judges have chimed in on this. We're nobodies in the space, right? Judges have chimed in on this. They've grown frustrated, which is why a lot of the action is moving. Um, it's forum shopping. They're going to forums where judges are not so familiar with this issue and filing in places where it's harder to track, but it's still as profitable as ever, especially state court in New York and places like that, or in California. Um, and the one thing that tells you everything you need to know is how many cases of accessibility have ever gone to trial,
I don't know the number, very few.
if any. And the ones that have usually end in the plaintiff law firm or the plaintiff or whoever's involved walking away from the case if they feel that they're not going to win. And in some cases, judges have now started to slap back and saying, in New York, in Brooklyn, there was a case recently, earlier this year, where the judge demanded that the plaintiff prove what remediation that they had demanded from the businesses that they had sued. That did they enforce that remediation on in the settlement agreements, and to provide the court with all the settlement agreements that they had entered into, and to see what enforcement of those stipulations was actually done. So there is, growing frustration with this. And I just feel for people with disabilities who are many ways sometimes being used for monetary gain. And they're part of what's, happening to businesses is also happening to the people with disabilities, because they don't know what some of them people that I've spoken to don't really know what they've gotten themselves into as litigants.
And we're almost done here, but I wanted to ask you one more question. Do you feel like there's a negative stigma now with people with disabilities because of this ongoing litigation?
I can't speak for that myself, but people I've spoken to certainly feel that way. And it's in my film as well. Um, so yeah, I mean, obviously, if one group of people are used uh, for serial litigation, then it may create a stigma around that topic. Yes, absolutely. And there are some very well-known folks that have the street cred in accessibility and disability rights that also feel the same way.
Well, you have done so much good work in this space, and you have been someone who has been an outlier and really someone who's making people ask the hard questions and bringing this back to reality and making sure that there is more common sense when we are looking at accessibility and compliance. So it's nice to have you finally on the channel, but you have done so much work behind the scenes. I know that very few people know that, but I do. And you've done so much great work. So thank you for coming on. Before we end, is there anything else that you'd like to say?
No, I enjoy watching your videos all the time. They show up on my notifications on YouTube, and I would say the same, that you've been one of those folks that have consistently tried to put out content to help people educate themselves without fear mongering or without trying to use accessibility as necessarily uh, a thing to be scared of rather than a thing to embrace, basically, because I believe that two things can be true at the same time. The world needs to be more accessible, and suing every business in America is probably not a good idea to do so. But I feel that more and more common sense needs to prevail, and good efforts need to prevail, not more government on the neck of small businesses, and not more lip talk from our politicians about that, and not being finger wagged by virtue signal keyboard warriors on any social site, should discourage, the genuine work that actually needs to happen, you know. And you know privately how I feel about a lot of that stuff.
Yes, I've got to have you back on. You're outspoken, and we need like things need like there needs to be people that are presenting different views. We don't need to just have one view. And I like a lot of your viewpoints. And your documentary is something that when people watch this, I'm telling you, pay attention for this documentary. When you watch this, it will make this like a lot of this will make so much more sense. And Nayan's going to take you behind the scenes into things I wasn't aware of when I watched, but it's a very powerful documentary, and I hope you are able to release that as soon as possible. Also, your reports, as I said, they are the standard in the industry, and I'm going to link to your report in the description. Nayan's company is Ecomback. I will link to ecomback.com in the description as well. And so, Nayan, just thank you so much for being on.
Thank you. I appreciate it, Chris. Have a great weekend.
You too.
All right. Bye-bye.
Bye.